Yes, Mr. Yobin.
My lord, I beg to crave my lord's indulgence. There's a contract matter, my lord. There's an urgency in this matter. Pertains to supply of some lighting conductor system, my lord. I have been supplying. I am a contractor who supplies to the defense for the past 23 years. Now the tender has come out, my lord, which is the bid is going to be opened on 21st July. Now the condition in the tender is as such that, my lord, there's a deviations from the categories that has been set by GEM, my lord. Now resultantly, what is happening?
Which entity is this?
My lord,
Assam Rifles.
Assam Rifles, my lord. Tomorrow, my lord,
Tomorrow is.
Obliged, Lordship. My lord, I beg to mention also item number 22, my lord. I'm not ready.
Reading?
2 years, my lord. Prove the petitioner, my lord.
Your Lordship, I'm for respondent 1 in this matter. The
objection?
respondent is MECL. I have no objections, Your Lordship.
Your objections?
No, Your Lordship.
2 weeks. Obliged, Lordship.
Obliged, Your Lordship.
Please, Lordship. I beg to mention item number 27, my lord. I have informed to the respondent also, private respondent.
What's the matter about?
This is regarding the claiming of pension by the two wives, actually.
It was hard, Lordship. It was hard.
Sir, then no adjournment.
Actually, it's not
What,
hard.
did you have to come up with some instructions or something?
Lordship, actually,
Then?
I just no, Lordship, because there is something is going on.
What is something? You can't tell the court what something is going on.
That I'll tell. Lordship. Only after 2 weeks, my lord. Because actually today, I'm going somewhere.
You don't have to say that. Don't tell the court you're somewhere.
Lordship.
The court takes precedence everything.
Yes. 2 weeks.
2 weeks would.
Lordship.
Though no excuse has been given by the counsel for the petitioner, however, on this prayer 2 weeks' time is granted. Correct? Yes.
Lordship.
Your Lordship, may I beg to item number 16?
16.
Come after 3 weeks, Your Lordship.
Here, Lordship, I am for the private respondent. Dispute between me and the petitioner, Lordship. Now the subsequent development, what happened, like all throughout that money has been depositing into the account of the managing committee. On the last 2 months, Lordship, again the problem started. Again the
What problem
subordinate officer, the block mission coordinator, Lordship, 2 months salary has been credited into her account. Now the comment affidavit is very clear, Lordship. Now my learned senior is digging the matter.
Oh, that is why you enjoy 1 more month's salary
That's
till the month ends.
Your Lordship, in this case,
Huh?
after the...
So we'll pass orders and salary to be released to anybody. Is that all right?
So, Your Lordship,
In the interim, till the matter is heard, salary to be remain in the account of managing committee.
Your Lordship, in this case, what's happened? Then in between, Your Lordship, inspection took place by the government.
Then hear the matter if you're ready.
So, Your Lordship, in this...
It's 19 matter, we'll hear it then.
So, Your Lordship, in this case, Your Lordship, because the salary is going to release at the moment. So, in this, if my area salary...
Submission of Mr. Sheikh is correct that there's been some, what by the SDSEO. He's giving salary to you now.
Lordship,
Block coordinator. If you're not entitled to it,
2 months.
then we'll pass interim orders that no salary be paid to anybody until the matter is heard. Then you'll come running to hear the matter.
Your Lordship, in this case, if my salary has been given, so Your Lordship, my petition will be in first.
No. Then you withdraw it now.
So, Your Lordship, I am asking for the instruction. This
No. We'll hear it. Give me the file. I'll not allow this kind of.
So, Your Lordship, after inquiry, the salary of mine was released. So, in such situation, Your Lordship, if my salary, if I got, then I will be doing my petition, Your Lordship. That's why I was not in a position to contact to my client. So, let me give my client's grievances over, then why I will be pursuing this matter, Your Lordship.
Yes, you took time last time also. Before that also. Yes. See, you on 18/5 you said that you filed an affidavit that you release salary be released to you. So and you prayed the matter be heard on 23rd of June. We'll hear it after 1 week. You come prepared. Mr. Devnath, please please that the matter be taken after 1 week. Please allow the matter to be listed as a fixed matter after 1 week. We'll hear it, finish it. If the inquiry report is there, is in your favor, well and good. Who's that? Yes.
I like to mention item number 29.
29.
29, Your Worship. The conducting counsel's mother is very sick, Your Worship. She's suffering from very high fever. That is why I kindly adjourn this matter for today, Your Worship.
Okay, 3 weeks, yes.
Your Worship, that I beg to mention item 24. This
Wait, let's just finish it. 3 weeks, yes. Yes?
Much obliged, Your Worship.
Yes.
24.
Yes, yes. Go ahead.
Lordship, I recommend item number 17 of today's list, Lordship. Lordship, conducting counsel Mr. P.B. Bonapu, his father is not well, that's why he has to leave for his next case today morning.
No objection.
No objection, Lordship.
Okay.
I was informed in the morning that.
Okay, 3 weeks, yes.
Then
Yes.
Item number 24, Lordship. This is a matter dismissal from service, Lordship. I need some more time, Lordship.
24 with other side.
I'm there, Your Lordship.
Government, Lordship.
1 week.
2 weeks also.
2 weeks, okay.
Apply, Your Lordship.
Please, Your Lordship, I beg to mention item number 21, Your Lordship. I pray for 2 weeks' time.
Dismissal from service matter.
You are appearing for, with whom here?
Sir S. Kumar, Your Lordship.
1 week.
2 weeks, Your Lordship.
So, okay, yes.
Anyway, Lordship.
That's it.
May I please, Your Lordship, I beg to mention item number 26, Your Lordship, that this matter will be taken after 2 weeks.
24?
26.
Was the matter heard at any length?
No, Your Lordship. It's connected with item 23, Your Lordship, on the left side.
Connected item number 23 with Kamal Hussain. Who's appearing?
I'm there for the response.
Is it connected to 23?
That was the submission on the last occasion.
Last occasion, Your Lordship.
Why you don't want to do it today? What's the problem?
As Mr. as the grandmother is in ICU, Your Lordship, so
Is there?
yes, Your Lordship.
He's the leading counsel in your chamber now, I gather.
He's leading with this matter, Your Lordship.
Okay. 23, 26 after 1 week.
2 weeks, Your Lordship.
Okay, 2 weeks. Yes.
Deploy.
May I please, Your Lordship, I beg to mention item number 25, Your Lordship. If this matter may kindly come up tomorrow, Your Lordship.
Any today or after 2 weeks?
Your Lordship, I'm appearing on behalf of Respondent 5. We have an objection to this.
You have no objection. So either today or
Tomorrow, Your Lordship. Senior counsel is out of station.
okay, pass over for a day.
Much
Yes,
obliged.
it's appointment, correct?
Lordship, yes.
Lordship, similar pray for item number 15, Your Lordship.
50.
15, 1-5, Your Lordship.
You've killed the list. 15.
Yes, Your Lordship. Which one? 15, okay.
After 2 weeks, yes.
Much obliged. Much obliged.
Main list item number 1.
May it please, Your Lordship.
You have to go to another bench, correct? You have to go to another bench.
Okay, Lordship.
Is regarding this the
sorry.
forest matter, right?
Yes, Lordship.
This is matter before another bench about me. Yes.
Much obliged.
Item number 2.
Lordship,
Yes.
this revision petition under Article
Wait,
227.
there's a caveat. Who's for the caveat?
We are on caveat.
You are Mr.
Prasuk Jain.
You are appearing for this, what's this? Astra Construction.
Construction, yes, madam.
Okay.
We are the decree holders.
You've been served copies? Right, a caveat petition 33 to 23. Seen the caveat application, stop. The counsel, Mr. So-and-so, is present on behalf of the caveat today and submits that copies have since been received. Caveat stands discharged. Yes, Mr. Singer.
Lordship, this revision petition under Article 227 has been directed.
227.
227.
Right.
Has been directed against two orders. By the first order, what has happened that in an execution proceeding, we raised the question of maintainability. That
in the first order.
First order. Our objection was set aside. Our objection was rejected. And
maintainability on what ground?
I'm coming to that. And the second, we filed a stay application that was rejected. Now, the admitted fact in this matter, there are 2-3 dates which are very important. The proceeding of the arbitration commenced on 23/3/2002.
2002. Okay.
2002. And award was published on 5/6/2015.
After 13 years.
After 13 years. Then.
What was the awarded amount?
Awarded amount, Your Lordship, 7 crore plus. And in the 7
interest?
crore plus, 4 crore was interest. Principal amount was 3 crores, and with the pre-reference award, it came to 7 plus crore. Then pendant light interest and post-award interest, all these things are counted. It becomes 15 crores, and out of this, only 3 crores, little plus, is the principal amount. And that interest is awarded on the face of a prohibitory clause, which has not been considered by the arbitrator. Anyway, that is the merit of the award.
Yes.
2 dates, Your Lordship, I would request this Honorable Court to take a note.
Yes.
The award was passed on the proceedings under Section 21 of the Arbitration Act commenced on 23/3/2002.
Okay.
And the award was passed on 5/6/2015.
5/6/2015. Yes.
And Section 34 petition was filed on 31/8/2015. 31/8/2015.
Okay.
And 2015 Amendment Act
came into being on?
Came into force on 23/10/2015. That means prior to filing of even Section 34 applications, the law as it stood on the
you
date,
file 34 automatic stay.
there was a automatic stay.
Okay, yes.
Which continued, and all on a sudden, after 7 years, they filed a execution petition on 14/12/2022.
14/12/2022. Okay.
When they filed this petition, we raised the question of maintainability.
Okay.
That this execution petition is not maintainable because the application under Section 34 was filed, and they filed this execution petition under the amended Section 36, which was amended after 2015 Amendment Act, without making any prayer that the deemed stay, which was there at the time of filing the Section 34 application, should be vacated. There was no such prayer. Now, when this application was filed, we raised a question of maintainability. The learned court heard the matter and decided that the petition is maintainable, and the learned court, Your Lordship, I'll take to page 144. 144 is the first order. 144 is the first order.
15.3.
Yes, I just take to your lordship paragraph 9.
Yeah.
In their show cause, the judgment debtor.
Yes.
In their paragraph 9, page 146.
Yes.
In their show cause, the judgment debtor has contended that the impugned petition as filed by the petition for execution of the arbitral award dated 5th June 2015 passed by the arbitral tribunal under the provisions of Order 21 Rule 11 CPC read with Section 36 of the Arbitration and Conciliation Act 1996 as amended is not maintainable, and the petition for execution itself is not the proper form. Your Lordship, we have relied upon the case of the Board of Control for Cricket in India, BCCI case, which was decided on 15 March 2018. In this case, Your Lordship, page 148, this case is referred. And I take to page 149. In 149, the learned court below even has observed. 149, Your Lordship, I may be allowed to read paragraph 15 of the judgment of BCCI, which is quoted by the learned court. The scheme of Section 26 of the Amendment Act is thus clear that the Amendment Act is prospective in nature and will apply to those arbitral proceedings that are commenced as understood by Section 21 of the Principal Act on or after the Amendment Act, and to the court proceedings which have commenced on or after the Amendment Act came into force.
What are the findings here? Finding,
Your Lordship, is this. The court has relied on certain observation made in HCC case which were only clarificatory in nature. And even in HCC case, paragraph 66, Supreme Court has said, the same bench has said that the law as decided in BCCI case shall hold good. Now, paragraph 21 of the order, page 162, in view of the settled position of law. What is that settled position of law, Your Lordship?
Page 162.
162, concluding para, page 162. In view of the settled position of law,
where are the findings?
Finding your paragraph 21, Your Lordship, page 162.
This is just 21. It's not a finding. It's just
in view of the settled position of law as laid
where's
down.
The reasoning in this part?
Hence,
that Section 34 unamended will be applicable in your case, and not section, and the application for them is incompetent in the sense that they filed under the amended section.
No reason has been given. No reason has been given, Your Lordship. And raised by the judgment that therefore not in view of the settled position of law as laid down in the commercial arbitration execution number 6 of 22 raised by the judgment debtor is therefore not maintainable. That means hence case to proceed in accordance with law, judgment debtor shall file an affidavit. Your Lordship,
laid down as raised by judgment debtor. I don't understand. In view of the settled position of law, as laid down in the, there's a line missing, I think.
No, laid down in the commercial arbitration.
Yeah, there is a line missing. Take out the soft copy.
There's a line missing from this.
Let's have a look on certified copy. Certified copy, Your Lordship, which is I think it is missing.
Your certified copy is a photocopy of this?
No.
And the copy annex?
Yes. I think that has not come. Laid down in the HCC judgment.
That order digit 15.3, right?
Just to assist my learned senior, they quoted STC. Then she said, relying on the law laid by STC, this is the finding.
Yes.
No, in the raise, it doesn't make any sense. Can you kindly get a correct copy? See, tab 21.
In view of the
certified copy, you see the same thing. There's a line missing.
laid down, I think in the typing itself it is missing.
You say therefore not maintainable, that means their petition is not maintainable.
Their petition is not maintainable.
If that's, this is what is recorded here in the order.
Yes. Therefore, in the settled position law is laid down in the commercial arbitration execution case number so and so.
No, it's the commercial arbitration refers. It's just a noting of then every
That copy
page.
has it, my lord. I can share a soft copy. I don't have a
Just read it out.
Yes, it says, in view of the settled position of law as laid down in Hindustan Constructions Company Limited, this court is of the considered view that there is no impediment to proceed with the execution. The objections raised by the judgment debtor is therefore not maintainable.
If you kindly file a proper separate copy, it's incomplete. It's a court of record, Mr. General. You kindly get supplied by tomorrow. In the course of hearing,
Your Lordship,
yes.
Because we may be allowed to file the copy in the internet, which is loaded in internet, with an affidavit we'll file
yes,
it.
you file anyway, but then a correct copy should be on record, Mr. General.
Yes, it should be, and we have filed the certified copy. But
copy
unfortunately,
it's got the same defect.
It
is not your fault.
We'll file it, Your Lordship. We'll file it.
List it tomorrow.
Tomorrow.
Yes, in the course of hearing, due to some defects in the certified copy supplied to the court, the certification 6, please be allowed to file
the correct copy downloaded from the internet.
I won't say download a correct copy. This matter tomorrow for.
With an advance copy to us so that we can refer to it.
You already have it there in your phone.
Just for the pagination.
They have.
No, just for the pagination for the court.
Item number 3.
Much appreciated.
Your Lordship, let it be day after.
Well, we have come from Delhi for this matter.
Because there's no consideration. You're a counsel. You can come from anywhere.
No. My only request is that the matter could be heard tomorrow.
Affidavit preparing will take little time. Let it be day after, Lordship.
Day after tomorrow. Yes. Enjoy the surroundings. You know, beautiful place.
It's a beautiful place.
Yes.
Absolutely.
Yes. No one for a petitioner. I guess Mr. Jha's case.
Your Lordship, he's here.
Mr. Jha, is he on leave?
No, Your Lordship, he was here. Your Lordship,
After some time.
Item number 4.
Number 4. Question, Mr. Bora. You finally short reply.
Your Lordship, we're praying for some time, Your Lordship, to file.
None appears for the petitioner. Respondents pray unallowed for the 1 week's time to file short replies. Yes. Oh, Dr. Sarab, I didn't see you. Sorry. I thought there was no one in front. Yes.
Well, in this case, I'm making a simple prayer before Lordship that the Industry Department is giving communication to the central government for issuing the clarification.
Yes.
And they are not issuing the clarification only. There is nothing to file affidavit. They may issue clarification only. That's all.
No, they'll issue that. It's nothing. It's not an affidavit. It's just a short reply, or only on that point only.
But it is post. Maybe I'll receive by today or tomorrow. I'll file it within 1 week.
They'll file it within 1 week, Dr. Saraf. Dr. N. Mosika, record Dr. Saraf's name. Who's there with you, assisting you, Dr. Saraf?
Mr. P. Bora.
P. Bora, yes. Mr. Dr. N. Mosika, please funds allowed further 1 week's time to file the short objection, yes, or reply, yes, or clarification rather.
So, on maintainability.
Short replies.
Item 3.
Why Mr. Jha disappear all the time?
My Lord, just finish, and we are giving as per the direction of the Chief Justice, my Lord, phone number to the Army Authority, my Lord.
Yes.
My lord, this is with regards to the promotion, my lord, challenging that disciplinary action. AFT, my lord, it's not because the judicial member has not been appointed. On the last occasion, my lord has raised a query that it's AFT's jurisdiction, my lord. So AFT is not functioning.
Correct. AFT is there, my lord, because the members keep coming by rotation.
They're not competing to pass any interim orders at all.
My lord.
Members, they're correct.
Their member, technical member is there, my lord. But
the technical member can't pass orders.
My lord, it's a judicial bench will be.
There's no bench. That's not sitting at all. You mean?
My lord, this is a promotion matter, my lord. There is no interim order.
There's no urgency also.
See, he can file it there. By the time pleading is complete, my lord, some member will be there.
My lord, that will give a what is there that let the notice. If the moment it will be there, the matter can be transferred, my lord. Can we transfer, man?
With what transfer? We'll have to remove it. You have to refile it there.
If that be to notice, may issue, my lord.
Notice issued. Why trouble them if it has to go to the AFT finally?
My lord, there also they have to file a reply, my lord.
There, you want to make two double replies?
My lord, that's one sort of, my lord. As of now, promotion order due to what, my lord? Due to the disciplinary case, where the disciplinary case does not commences only after the hearing of charge, my lord.
And what?
My lord, that's submission of the.
Yeah, Dr. Mizra.
My submission is by the time he files a petition.
It's a promotion matter. It's not impending something matter that that you lose your job or something like that.
My lord, the petitioner has to file a habeas corpus today, last occasion, because of illegal confinement, my lord. The same petitioner, my lord.
You filed it in the division bench.
Today it has been disposed of, my lord.
Same person.
Same person, my lord. They have illegal. My lord.
Why illegal confinement? What have you done?
That's they said that summary of evidence. Court of inquiry is yet to finish, my lord. The summary of evidence, how no hearing of charge has been done. That will be.
No, why habeas corpus?
My lord, because no communication, illegally detained.
Correct.
Yes.
But he is not cooperating with investigation, my lord. After 5 notices, we arrested him, my lord, and informed them that you are arrested, grounds of arrest, everything. Still, he files a case.
I think you take your chance before the Assam Armed Forces Tribunal. We will not have you riding with 2 feet on 2 boats. Yes, this is reported by Mr. Arjha that at present the Assam or the Armed Forces Tribunal is not a judicial member, but technical member is present. Stop. This is also the submissions concurred by by Dr. N. Moska, the TSG. The TSG stopped. An exemption of the matter, it appears to be a matter regarding promotion. No urgent interim relief is sought for in the said application. As such, as such ability or opted relief, matter stands closed with liberty to the petitioner to approach appropriate forum.
Item number 5.
May I please?
What is this?
This in this petition, the petitioner is only seeking some direction, that.
But what direction can he seek?
My lord,
have you filed your objection to maintainability?
My lord, I'm praying for some. I've received instruction, my lord.
Mr. Sahai.
2 weeks time I'll file it. I prefer 1 and 2.
The objection I file it within 1 week if Lordship grants me that time.
You are filing also? No. Okay. Let them file the objections. Yes. What miscase is this?
Miscase, my lord, regarding some certain additional documents, my lord, we came to know about certain additional documents. So only pray that these documents may be taken on record, my lord.
Additional documents, matter not been admitted, also notice has not been, it's just at the threshold, and you only bring additional documents. We'll keep this pending. Miss case number so and so has been filed in the main writ, Miss case number 144 has been filed in the main writ petition. Matter is kept pending for consideration at the later date. Stop. In the meanwhile, in Miss case, stop. In the main case, that is Dr. N. Mozika, the DCI, for 1 and 2, and Mr. SI for 3 to 6. allowed 1 more week's time to file objections. Yes, this thereafter.
2 weeks time.
1 week's time. Finish up with the matters.
Item number 6.
Yes, what instructions you're supposed to receive?
Lordship, we've written actually to the Revenue Department, but then they have no comments to make. So now we are awaiting some instructions from Supply, Lordship.
Supply?
Lordship.
What's supply going to do with this reciting of the...
Actually, there's much confusion because there's nothing directly...
You call the officers to your office and explain the matter. This entire case. What is this? You can't have... We can't be wrong instructions.
Lordship.
Writing will not solve anything. None for a petitioner. None appears for a petitioner. MS NG Shidal, senior advocate, submits that due to slight confusion with some intra-departmental confusion, based on 1 week further time to obtain instructions. This thereafter and so on. So.
Item number 7.
Yes.
Wait, please, Your Lordship. Your Lordship, we pray for another 2 weeks' time to file a rejoinder.
Why? How many times you've prayed?
This is the third time, Your
The
Lordship.
third and final time, yes. Take down. Response allowed for the 2 weeks' time to file rejoinder applications.
Obliged, Your Lordship.
8.
Anti-shower.
Looks, this is the election matter. There are 3 miscellaneous applications, Malutz. One is by the Election Commission insofar as Malut's removal of that EVMs is concerned. One is a preliminary objection filed by the private respondent, Malutz. Lordships had heard this matter at some length, and then your Lordship, some clarifications were sought from the respondent.
Regard to?
Regarding maintainability of the election petition.
Okay.
Your Lordship.
So who wants to do it first? I mean, the EVM or the municipal election? Yeah, that's got more urgency.
Yes.
Where elections happening anyway soon?
No, Lord, but as per the guidelines, Lord, we have to follow
2024, Malutz.
Lord, I filed in additional affidavit, Lord. Your Lordship, on the last occasion, wanted to ascertain.
And what does the additional affidavit say?
Lord, your Lordships wanted to ascertain the manner in which the EVMs are stored, my Lord. My Lord, my affidavit, my Lord, dated 28th of June. In your Lordship's previous order, your Lordship had also sought for pictorial proof, my Lord. Lord, page 5 of my annexure 1 of my additional affidavit, these are the specially created cases as per Rule 57, your Lordship.
So one box stores how many? What's inside this blue box?
Single each, my Lord. They are sealed, my Lord. Your Lordships will see some threads. These are sealed, my Lord.
The grey boxes on top?
My Lord, one is for the CPU, one is for the... my Lord,
so one complete unit comprises what? One white, one grey and one blue?
Yes, my Lord.
One is the balloting unit.
Yes. Lord, one is the ballot unit, one is the control unit, and one is VVPAT unit.
Just let me understand it. Wait. One is the ballot unit.
Ballot unit, my Lord.
Ballot unit means the one you punch.
That's the one where we press the button.
Okay. One is the ballot unit. Okay. Then next is the
control unit.
Control unit, my Lord.
With the officer.
Yes, my Lord.
Okay.
And one is the VVPAT, my Lord.
VVPAT is the reader. That
VVPAT is that paper.
Okay. Right. What number in this case? Let's come back to your Mrs. application. So,
application number 16, my Lord.
But you have no quarrel with this, with the machine, correct?
We have a quarrel
only
with
the other machine, not the one he's seeking to release.
Well, the rules are very clear. Once my learned friend clarifies, well, I'll just take 1 minute to just take your lordships to the relevant rules.
Yes, my lord. Lord, kindly have Rule 57, my lord, of the Conduct of Election Rules 1961.
I get to go. RTI.
66. 66, no?
66. Rule?
Rule 66A, my lord.
Okay.
Within 66A, my lord, there's a 57C.
Okay.
Look, 57C talks about sealing of voting machines. This is what was indicated by Mr. Paul on the last occasion. This was the one you indicated last time.
Yes.
Yes, my lord. So, my lord, I have also, as volume 2 of my affidavit, my lord, handed enclosed the entire manual, my lord. Now, my lord, this manual is in furtherance of the rules, my lord. On the last occasion, what Mr. Paul had indicated was that there's some ambiguity between the manual and the rules. However, there are no ambiguity, my lord. The rules are in furtherance of, my lord, the
now,
rules.
Mr. Paul, just to recollect, you have a complaint only one EVM,
Polling
correct?
station, my lords.
One polling station, sorry. One polling station and with one machine. That means.
Ballots.
Okay. And they're seeking release of all the machines used in the constituency.
Ballots.
Yes. So how do you say that they cannot be segregated?
I'll just very quickly just take your lordship. If your lordship, the additional affidavit file, your lordship will quickly come to page 3 minutes.
1 second.
Nine lines from the bottom of paragraph 4 minutes, if your lordships have it. Page 3, 9 lines from the bottom of paragraph 3 minutes. That during the course of hearing, if your lordships.
Yes.
Well, I'll just read it quickly. That during the course of hearing on 24/5/2023, only the extract of chapter 12 of the manual was handed over to this honorable court, which deals with the storage of EVMs generally, which perhaps may have brought about a question in the mind of this honorable court regarding the storage of EVMs and after the conclusion of the election. That the Chief Electoral Officer states that the complete manual ought to have been placed before this honorable court to point out that chapter 14 deals with the storage of EVMs after the decisions are concluded. So, Millets, there is a chapter 14. In the manual, if your lordships quickly have chapter 14, Millets. Chapter 14, Millets, deals with counting of votes, and your lordships would find it at page 70.
Yes. Yes.
Millets, I will jump and I will take your lordship straight to 14.13 at page 79. We'll start from 14.12, Millets, if your lordships kindly have a look at 14.12.
Yes.
Your lordships have it, Millets? Yes. May I read? After completing counting of votes, keep the EVMs and printed paper slips of VVPATs in the strong rooms. Do not open the strong room till the completion of the election petition period, that is the EP list, is received from the respective High Court. Millets. Thereafter, Millets, storage of VVPAT paper slips after expiry of the period of filing of limitation. In the case of elections where no election petition has been filed or no other court cases are pending, and after the Millets, this is not relevant for our purposes, if your lordships come to B, Millets.
Yes.
In case where election petition has been filed, the following action should be taken. if the EVMs or counting of votes are the subject of the election petition, the EVMs used at all polling stations in the constituency concerned should continue to be kept in the safe custody of the district election officer till such time that the election petition is finally disposed of by the courts. This is their own manual, my lords. I have nothing further to add to this.
That means for the entire
constituency, my lords, the number of balloting units that are to be used, my lords, are to be
all polling constituencies.
Very specific.
I've marked this portion, my lord. I was going to indicate.
How do you answer this?
Yes, my lord. My interpretation would be, my lord, in this particular case, my lord.
What about this? 1 second. Just come to the next one.
Well, as it says, if the EVMs of counting of votes are not the subject matter of the election petition, an application may be moved to the concerned court for allowing the EVMs concerned to be taken out of the strong room for any further future election or any other purposes of movement, physical verification. If any election petition is pending, the VVPAT slips shall be preserved till final disposal of the election petition. The slips will then be disposed of as per the process maintained, and so on, so on, so on. So, my lords, the moment there is a challenge, my lords, an election petition where there is a question to the machine and the election process, the VVPATs or the EVMs, my lords, in respect of the entire constituency are to be kept in. Sir, why, your lordships? I'll show that. It makes a lot of sense. If your lordships kindly quickly come back to the affidavit filed by my learned friend where they have given pictures, my lords. Picture number 6 and picture number 7 will explain why.
They're all stood together.
Exactly, my lords. 6, your lordships will see how it is kept. And 7, your lordships will see that there are separate rooms for separate constituencies.
Yes.
So the idea is, my lords, that it should not be, my lords, touched till such time your lordships are seized of the matter and deciding the matter. That's all, my lords.
Lord, my interpretation would be, if the issues with regards to EVMs, my lord, many EVMs, my lord, and counting of votes. Here the issue is not with respect to EVMs.
No, but one thing is the physical aspect, Mr. Nobi.
Yes.
You see, the physical aspect is that if all the EVMs used for the entire constituency, right?
Yes, Lord.
So you just say 10 EVMs for use.
Yes, Lord.
Okay. Then 10 EVMs used. Then the election petitioner he questions the use of one particular EVM in a particular polling station. That something has been wrong, been tampered. It didn't show the correct results, and so he lost whatever. Now, if your SOP is that after the election for every constituency, those EVMs used for a particular constituency are kept in a special room under lock and key under the custody of district election officer, and as per the manual, that it should not be touched. So how will we answer that? Because if storage is that EVMs are totally kept separate and they all jumbled together, that EVM for this constituency, the serial number is kept, then maybe it can be taken off. But the thing is that if it's for one, and it's very clear. See, it's for all. It does not say that the EVM supposed for a particular polling station. It said if the EVMs or counting of votes are a subject of election petition, the EVMs used at all polling stations in the county concerned should continue to be kept.
The issue in this particular election petition is not the counting of votes, my lord. It's not the EVMs. It is one particular EVM, my lord, where the mock poll was not deleted.
Exactly.
Now, my lord, while adducing evidence, my lord, your lordships will not be calling for all the EVMs, my lord. It's only
will not be calling, but the thing is that suppose there might be a chance of, we will not say that it happens, but
yes,
you never know what happens.
Well, the idea is that election commission is above everybody, my lord, so they don't want to get involved in anything. They say that as long as there is a challenge, just leave it.
Like they say, it's sanctimonious. Absolutely. Kind of thing. You keep it there, you do whatever you want, you read it, you download it and see if it's true, then it's fine. For sure, there's no.
But I leave it to your lordships, because
in view of this provision, in view of this provision,
I did pose a question.
Yes.
But no answer was forthcoming, my lord.
Take down. Miss case number 16, 2023 and number 6, 2023. Stop. This is an application under section 151 of the CPC. For clarification that except for one EVM used in polling station number 52 with ballot number, just keep dash, we'll fill that in later. The remaining 59 numbers of EVM capital dash capital VVPAT being not the subject matter of election petition be released from the strong room for further use and transportation by the applicant number 1 and 2, respondent, what in the election petition?
Well, we are not respondents, we have come by
applicant is number
intervention.
1 and 2. Stop. Next paragraph. Mr. Philemon Nong, General Counsel for the applicants, submits that as the only issue raised by election petitioner is with regard to the mock poll data that had not been erased from the said EVM, there was no necessity for the other 59 EVMs used in the polls for the constituency to be retained, as they will not be needed for the purpose of evidence. Stop. He therefore prays that appropriate orders be passed for release of the 59 EVMs for the EVMs, and in this regard has also filed an additional affidavit detailing therein the manner of storage of the said EVMs. So, next paragraph. Mr. K. Paul, appearing for election petitioner, however, has voiced his objections and has drawn the attention of this court to clause 14.13
B, capital B.
More particularly, which deals with the storage of VV capital PAT capital paper slips and in the case where any election petition has been filed, the action has been prescribed at 14.13 capital B. Stop. He submits that as stipulated by the manual, if EVMs or counting of votes are the subject of the election petition, the EVMs used at all polling stations in the constituency concerned should continue to be kept in the safe custody of the district election officer, till such time election petition is finally disposed of the courts. He therefore submits that the prescription not allowing the release of the EVMs as prayed, the miss case has no merit. Next paragraph. Having considered the submissions of the counsel of the parties and examined the application, as also clause 14.13 capital B, it is clear that the stipulation as submitted is correct, and that the EVMs used at all polling stations in a particular constituency should be kept in safe custody till election petition is disposed. Stop. Next, panel's view of the matter, the miss case is not allowed and disposed of accordingly.
D.
Yes.
Two miss cases. Minus one. Intervention.
Yes.
This manual will be helpful, my lord, in this particular case.
Yes, this is your copy?
No, my lord, that's your lordship.
This is your copy?
No, this is the court's copy.
This is volume 2, filed along with it.
My learned friend has been kind enough to file it. It's thrown a lot of light as to how the counting is to be done.
Yes.
Well,
so you have more ammunition.
Looks like
or less.
Well, it's the other miscellaneous case.
Other miscellaneous case, Your Lordship.
Yes, what's the second again? Can you? 16 disposed, nahi?
I draw your Lordship's attention, Malats, to the order dated 25/2/2023. It's in miscellaneous case number 2 of 2023, Malats.
This case number 2, yes. Yes.
Your Lordship, I have raised a question of maintainability.
On?
Maintainability.
On limitation.
On limitation, Your Lordship.
Yes.
I may be allowed to complete my submission, Your Lordship.
The last media submissions on 22nd of May. Yes, here kindly, you know,
I have submitted
just
last
refresh
time.
the memory of the court a bit.
Yeah.
I read your matter today, Mr. Paul. Yes.
Very limited issue in that.
Limited issue.
Because this concerns the dismissal of your entire election petition.
Your Lordships were not satisfied with the objection raised, Malats, because what is being pointed out, I had taken your Lordships to the General Clauses Act.
General Clauses Act is also
And
not
that
applicable.
two
Your
couple of
Lordship.
judgments had been placed, Malats, which in my humble submission were rather aiding the election petitioner than the private respondent. Your Lordships will hear us, Malats.
Thank you, Your Lordship. Last time I have said that the election petition was not applicable, was
Not maintainable.
was not maintainable because both the Limitation Act and also the General Process Act is not applicable.
No, Limitation Act not applicable, that's correct.
Yes. I have referred to, I have relied on certain judgment of the Supreme Court.
Yes.
1974, Volume 2 SCC, 133.
You gave this a book?
I have given the, yeah.
You gave
Yes,
today?
a book,
133.
Yeah.
You kindly give this the books of court master so they can bring the books. Representative People Act. Barred by section 81, yes. I remember now, you said it's a holiday or something, right?
Yeah, holidays.
Filed on the next working
day.
45 days ended on a holiday, Malats, so it was filed on the next day.
This case of SEC 1974.
No, this one, Mr. Sangma, if I correctly remember, you already placed it last occasion.
Yes.
Then the court is not satisfied. The court asked you to, if you can present some authorities in support of your case, that,
Yes,
you know,
yes.
that intervening holiday or, you know,
Yes,
a very
yes, Your
45
Lordship.
days taken as a, you know, like
Yes, Your Lordship.
strict 45 days, yes.
This case, the limitation fall on Saturday, but they have filed Saturday and Sunday. Sunday also holiday, Saturday also holiday, and they have filed on Monday. And the Supreme Court has deal on this matter, and they have.
Which
they have
case is this?
This one SEC 1974.
No, that one you placed last. I think that one you all.
Yeah.
Okay, finally, please read. No problem. Yes.
I
Carry on,
will
carry on.
refer only to two para only, Your Lordship.
Yes.
Para 19 and 25.
Para 19.
19 and
Excuse me.
25. Para 19, let me come to page 148, my lordship. The second para.
You read para 19. You say para, read para 19.
19. A full bench of this court had in NP Panuswamy versus returning officer Namakar constituency and other consider the provision of the act to determine whether anything connected with election can be questioned at an immediate step. In that case, the rejection of a nomination of a candidate in election under the Act was sought to be challenged by a petition under Article 226 of the Constitution. After examining the various provisions of the Act, Fajar Ali Judge observed at page 231 that it should be noted that there is no provision anywhere to the effect that anything connected with election can be questioned at an intermediate stage. Again, at page 234, it was observed, if Part 15 of the Constitution is a court by itself, that is, it creates rights and provides for their enforcement by a special tribunal to the exclusion of all courts, including the High Court. There can be no reason for assuming that the Constitution left one small part of the election process to be met, the subject matter of contest before the High Court, and thereby upset.
Okay, now you read the other parties.
Then next, the observation that provision of the Act are self-contained court, were also met in the case of Venkatas Warau referred to earlier. In that case, in a trial of an election petition, after the issue was framed, the appellant made an application to the court for impleading 1R, but it was dismissed. The first respondent then filed an application under Section 86(1), praying for dismissal of an election petition on the ground that there has been non-compliance with Section 82B of the Act, inasmuch as R, against whom corrupt practice had been alleged, had not been made a party. The appellant made an applicant seeking to withdraw the allegation against R, and in the alternative, to implead him as a respondent. It was also prayed that delay in making the application may be condoned. The learned judge of the High Court, trying the election petition, dismissed the aforesaid application and refused to condone the delay. One of the contentions urged in the appeal was that Section 5 and Section 29(2) of the Limitation Act 1963 were applicable to the case, and the High Court and this court had power to condemn the delay made by the election petitioner in impleading a necessary party. This plea was rejected. Mr. Justice delivering the judgment of this court for himself and Hidayatullah, Chief Justice, after examining the relevant provision of the Act in detail at distinct. It is well settled that amendment to a petition in a civil proceeding, and in addition to party to such a proceeding, are generally possible, subject to the law of limitation. But an election petition stands on a different footing. The trial of such a petition and the power of the court in respect thereof are to consolidate and amend the law of limitation, or are all circumscribed by the Act. The Indian Limitation Act of 1963 is an act to consolidate and amend the law of limitation of suit or other proceeding, and for the purpose connected therewith. The provision of this act will apply to all proceedings and such special criminal proceeding which can be taken in a court of law unless the application thereof has been excluded by any enactment. The extent of such application is governed by Section 29(2) of the Limitation Act. In our opinion, however, the Limitation Act cannot apply to proceeding like an election petition, inasmuch as the Representation of the People's Act is a complete and self-contained code, which does not admit of the introduction of the principle or provision of law contained in the Indian Limitation Act. 25, Your Lordship.
Yes, read.
For all these reasons, we have come to the conclusion that provision of Section 5 of Limitation Act does not govern the filing of election petition or their trial, or in this view, it is unnecessary to consider whether there are any merits in the application or condemnation of delay.
Yes.
Again, my Lord, I will rely on another Supreme Court judgment.
Yes.
SCC 1999.
1999 SEC.
Yes.
Yes. What volume 99? What SEC?
Page.
No, 99 volume.
Volume 8.
Volume 8.
Page 532. Your Lordship. 532. I will refer to paragraph 12 and 13, Your Lordship. I want to come directly to the last third line of page 538, Your Lordship. 538 on third line.
Page 538.
Yeah, 538, the third line, Your Lordship.
Yes.
In sub-bill case, the benefit of Section 10 of the General Clauses Act was denied to the election petitioner, and the election petition not filed within the prescribed period of 45 days, which expired during the summer vacation, but filed on reopening of the day of the High Court after the summer vacation, was held barred by time because of the exception contained in the notification regarding the hearing of election petition, etc. during the period of summer vacation.
So one thing, does it mean the judgment says that even summer vacations with the hearing application would carry on? Is that correct?
Yes.
What do you mean to say?
Notification is there.
Yes.
That
There
notification was there that
notification.
notwithstanding the summer vacations, the election petitions matters would be heard.
Would be taken up.
Okay.
That exception was there.
Yes. Then.
But
Yes.
then 13, Your Lordship.
Yes.
We are not impressed by the argument of the learned counsel for the applicant that in view of the serious charges which had been leveled against the returned candidate in the election petition, the same ought not to have been dismissed on the ground of limitation, as the purity of the election process is required to be maintained. There is no quarrel with the proposition that it is the duty of the court to maintain the purity of the election process, but at the same time, there is no gainsaying that law of limitation may harshly affect a particular party. But it has to be applied with all vigor and when the statute so prescribed. The court cannot extend the period of limitation on equitable ground, more particularly in the matter of filing of election petition under the Act, since it is common ground that the election petition is, in the instant case, had been filed 1 week after the expiry of the period of 45 days. It was clearly barred by time. The High Court was, under the circumstances, fully justified In dismissing the election petition on that ground, we do not find any merit in this appeal, which accordingly failed and is dismissed, but with no order as to cause.
So benefit of Section 10 of General Causes Act could not be given.
Will not be given.
Right. Anything else?
I wanted to rely again on another Supreme Court judgment, Your Lordship.
Yes.
2018, Volume 9, Supreme Court Cases,
Yes.
818.
Number? Which number?
808.
808.
Yeah. 2018, Volume 9, Supreme Court Cases, 808.
Yes.
I want to go straight away to Para 8 and 9, Your Lordship.
Yes.
In Charan Lal Sahu versus Nandi Kishore Bhatt, the two judges bench held that there is no common law right to challenge an election since it is purely a matter of the regulation by the term of the statute. The right being statutory, the term of the statute must be complied with. A three-judge bench of this court in Laxman Das Arora and Ganasi construe the provisions of Section 81 of the Representation of Peoples Act 1951, which prescribe a period of 45 days to file an election petition. Dr. A.S. Anand, Chief Justice speaking for the court, held thus, SCC page 535, 36, para 7. It is caught here, Your Lordship. On plain reading, Section 81(1) laid on that an election petition calling in question any application may be presented in one or more of the ground specified in subsection 1 of Section 100 and Section 101 of the Act to the High Court by any candidate at such election or by an elector within 45 days from, but not earlier than, the date of election of the returned candidate, or if there are more than one returned candidate at the election and the date of their election are different, the latter of those two dates. The Act is a special code providing a period of limitation for filing of an election petition. No period for filing of an election petition is prescribed under the Indian Limitation Act. The Act, insofar as it relates to presentation and trial of election dispute, is a complete code and a special law. The scheme of the special law so that the provision of Section 4 to Section 24 of the Indian Limitation Act do not apply. If an election petition is not filed within the prescribed period of 45 days, Section 86(1) of the Act, which provides that the High Court shall dismiss an election petition which does not comply with the provision of Section 81 or Section 82 or Section 107, shall strike away attracted. Your Lordship. Again, I would like to rely on another Supreme Court ruling. Satpal Singh.
They give the citation?
Yeah, Satpal, I have. Yeah. I will give.
No, it's not an SEC.
Manu Batra. Do you have extra copy? Yeah. I'll go straight away to para 2 and para 2, my lord, and 7 line from the bottom and 5 line from the top. 7 line from
Read
the
the whole
bottom.
para 2, no?
Okay.
Count the lines
Alright.
7 and 2.
In view of the clear language of the notification, there is absolutely no doubt that the appellant had to file petition in the High Court before the expiry of 45 days. And for this purpose, the High Court would be treated as open. The notification further makes it clear that during the period of petition except Sunday, appeal petition will be received in the High Court at Chandigarh from such period as may be chosen the present same. The stress, however, was laid by Mr. Goyar on the word as may choose to present. This, however, does not mean that the litigant has a right to avoid the period of limitation and exercise the option or discretion whether to file the petition or not. In fact, the very purpose of having summer vacation is not to close the office, but it's meant only to give vacation to the judges. In literal sense of the term vacation, period cannot be treated as holiday, as envisaged by the provision of limitation. However, we need not go into the said broader question because of the view of express language of notification. There is no bar to the plaintiff to file the election petition, and no option or discretion arises to the appellant. If the court is open receiving election petition, the question of open option or discretion does not arise. If he deliberately does not choose to file the election petition within the period of limitation, he does not at his own risk. In the instant case, since there is a common ground that election petition was filed 1 week after expiry of the period of 45 days, the petition was clearly barred by limitation. The High Court was therefore fully justified in dismissing the election petition on this ground. We therefore find no merit in this appeal, which are accordingly dismissed. In the circumstances of the case, there will be no order as to cause.
Yes.
Yes, sir.
But you see one thing, Mr. Sangma, in both the cases which have relevance in your objection, there are specific notifications by the respective high courts that says that there is no bar to election petitioner coming, like if it's a holiday or summer vacations, correct, to file election petition. Now his case, if I understand correctly, is that the court was closed, the registry was closed rather. That is why he could not present the election petition within 45 days. and for that to be considered to be within 45 days. That's the only thing.
Yeah. I would like to refer to another judgment, though it is a Calcutta Kerala High Court.
It's got persuasive value. Yes. Because the line runs all the judgments, okay, fine. There's no question of limitation act applying.
And even General Process Act.
General Process Act Section 10 will apply in some cases if there are no notifications or something like that. But in this both the cases you cited where they have dismissed the election petition is because there is a specific notification saying that they could have filed it within the 45 days. The registry will be open, but they did not file it, so they could not take, notwithstanding the fact that it was a vacation or it was a weekend. That's the only thing. Yes. Next decision.
The first case, Your Lordship, the last date it was supposed to be Saturday. It was closed, and Sunday is Sunday. They filed on Monday, but the court did not consider. Your Lordship.
In this character judgment?
No, in the 1974 judgment.
Okay, no, let him meet that argument.
Yes.
Yes.
And that is why in the last paragraph.
No, come back. What other judgment you have which supports the case?
In the Kerala High Court.
Okay, just give the citation. Yes, we'll do it fast. Yes.
2022 live law Kerala.
Live law is very unreliable because you don't have it from SC online.
We have not opened. We have not printed.
Neutral citations would be available. I think the high courts have now.
Yeah, but live law sometimes they insert
live law in
their own.
Manupatra is very dangerous too.
Very dodgy. It has happened personally to this court also in the sense that
very dangerous. I have burnt my fingers.
Quote these paragraphs down, and when it's been quoted, you then cross-check by the private secretaries. They find that the paragraph is downloaded from the evidence been given. Like live law doesn't exist there in the main judgment.
I have burned my own fingers, Manoj. I am aware.
That's the thing. So live law is yes, like live wire. Yes. Catch yes.
My humble submission, your Lord, if it is not going by the statute,
but you're relying on. No, okay. You just say what does the judgment say? What
I will favor one another.
No. What does it say?
It says that is this. They have
which part? Just say which
dismiss.
Part. Which line? Para 9.
Para 9. Having heard the learned senior counsel appearing on both sides, this court finds little merits in the contention raised by the petitioner in the above IA. The prayer is for rejection of plan under Order 7 Rule 11D of the court. Section 81 of the Act stipulates a period of 45 days from the date of election of the returned candidate to file an election petition. Before this court, there is no dispute with respect to the date of the returned candidate was elected. The election petition was filed only on 13/7/2021, whereas the stipulated period of 45 days expired on 16/6/2021. By virtue of the authoritative pronouncement of the Honorable Supreme Court in Hukumat Den Narayan Yadav, Supra Sumadivi Supra and Lakshman Das Arora and Ganesh C. Lar, 1999, Nakit SEC 532. The legal position that Section 5 of the petition does not apply to election petition under the Representation of the People Act is settled. Your Lordship, I have given all the citation of the Supreme Court. Secondly, Your Lordship, the authority who conducted this election was not made a party, Your Lordship. Only the candidate was made the respondent. And the respondent, either number one or the rest, they don't have any hand in this process of election. They are contesting only. They are the person or this.
Right.
And the third thing, I have some question on the format of affidavit.
Well, that's your objection to that.
Of course, though I'm just submitting orally, you know.
No, what objection do you
on
have?
the ground of 45 days minutes.
The objection?
Yes.
Then
The application filed before Lordships is only on 45 days.
In case of any proceed of the case, I may be allowed to submit my written.
Of course, that is your right. No, you only gave only on 45 days. That's all.
Yes, Your Lordship,
No other objection.
I have given all the citation.
No. Your objection in the MIS case only on
Yeah.
the limitation. Okay.
Limitation.
Yes,
Secondly,
we'll stick
the
to that
authority
only.
also. The authority concerned also in my application. This election officer was not met the party.
They're not necessary party actually now. Yes.
Jyoti Vasu.
Yes.
Jyoti Vasu specifically on this.
Not necessary, yes. That's why they strike off. When any election president made party, they file an application for striking off, which the court allows also.
For the factual part, Maluds, the results were declared, Maluds, on the 2nd of March 2023.
2nd of
March, Maluds.
Yes. Elections are declared, right?
Maluds.
Okay.
And Maluds, this election petition came to be filed before your Lordships, Maluds, on the 17th of April 2023.
Okay.
If we were to calculate, Maluds, 45 days, it ends on the 15th of April 2023, Maluds, which is a Saturday. Give me a calendar.
Yes.
Well, it's also noteworthy, Maluds, that 14th of March was also a holiday.
Why?
It was a holiday on account of Maluds. I'll just place Maluds why it was 14th was a holiday, 15th was all a Saturday, Maluds. I'm not counting 14th because till then limitation is surviving on insofar as I am.
Even then.
I'll just place Maluds why on what account was 14th a holiday. 15th was a Saturday, Maluds. 16th was Sunday. 17th it has been filed before your Lordships.
Yes. Yes.
I will now just draw your Lordship's attention to section 10 of the General Clauses Act.
Hi. General Clauses Act.
General Clauses Act.
Go down.
Court Master. May I read section 10? Commencement of computation of time, where by any central act or regulation made after the commencement of this act, any act or proceeding is directed or allowed to be done or taken in any court or office on a certain day or within a prescribed period, then, if the court or office is closed on that day or the last day of the prescribed period, the act or proceeding shall be considered as done or taken in due time if it is done or taken on the next day afterwards on which the court or office is open.
Yes.
Provided that nothing in a limitation, my lords, is not relevant, and subsection 2, my lords, is of some relevance to us, my lords. The section applies to also to all central acts, regulations made on or after the 14th day of January 1887. Now, the judgments which have been placed before your Lordships, my lords, there is no dispute that the Limitation Act does not apply. If I miss it by a day, my lords, had I not filed it on the 17th, and I had filed it on 18th, and I had sought for a day's condemnation before your Lordships, my lords, that was not maintainable in law, and the judgments which have been placed, my lords, would cover this issue. Now, the two judgments, my lords, that I thought I would have to distinguish before your Lordships, my lords, the first is, my lords, the 1999 decision. What has been placed before your Lordships is paragraph 12, my lords.
Thank you.
And what is more relevant for our purposes is paragraph 11 at page 536, my lords. If your Lordships permit me, my lords, I will read from paragraph 8 because this is squarely my case. Section 10 of the General Clauses Act. May I read paragraph 8 onwards, my lords? The next question, however, which arises for consideration is whether Section 10 of the General Clauses Act 1897 can apply to a case where the prescribed period of limitation expires during the vacations of the High Court. Section 10, well, it has been reproduced.
Yes.
The proviso to Section 10 makes the provisions of Section 10 inapplicable to cases where Indian Limitation Act applies, and since the Indian Limitation Act does not apply to election petitions filed under the Act, Section 10 of the General Clauses Act in turn would apply to the filing of election petitions also. So, it first settles the dispute whether Section 10 applies or not. Section 10 applies to election petitions. Accordingly, according to Section 10 Supra, an act should be considered to have been done within the prescribed period if it is done on the next date on which the court or office is open. The applicability of Section 10 would, however, depend on the facts of each case and the manner in which the High Court transacts its business during the period of vacations. The rules and orders of the Punjab and Haryana Court do not settle the calendar of summer vacations. It is an admitted case of the parties that the settlement of summer vacations is done by issuance of a notification which contains all matters connected therewith. The Punjab and Haryana High Court had, as in the previous years, issued a notification on 27/11/1995, settling the summer vacations and providing therein the manner in which the High Court would function during the summer vacations. Whether the benefit of Section 10 of the General Clauses Act can be availed of to save the period of limitation in the present case would therefore depend upon the terms of the notification issued by the Punjab and Haryana Court on 27/11/1995. The notification inter alia provides, it is hereby notified for general information that the Court of the Punjab and Haryana at Chandigarh will be closed for civil business except for hearing election petitions and or matters arising out of the Representation of Peoples Act 1951, urgent civil appeals, petitions, etc., including petitions under Article 226 of the Constitution of India on account of the long vacations of the year 1996 from 1/6/1996 to 30/6/1996, both days inclusive. The court will resume sitting on the 1st of July 1996, Monday. During this period, except on Sundays and holidays, appeals, petitions, etc. will be received at the court at Chandigarh from such persons as may choose to present them. The above notification unambiguously provides that during the summer vacations period from so-and-so to so-and-so, while the High Court of Punjab and Haryana would have remained closed for civil business, it would be open for hearings, election petitions, or any other matter arising out of the Representation of Peoples Act. Now, the question here is, here we're not talking about vacations, we're talking about a weekend. Weekend meaning, 15th was a holiday. Admittedly, 16th was also a holiday. The registry of this Honorable Court was also on holiday. They were not functioning. If they were functioning, then I would have to answer that. The registry of this Honorable Court was also not functioning.
Yes.
And on the next day, that is on the 45th day. It would rather be the 44th day, because 14th was a holiday. The election petition has been filed before your lordships. So, this judgment, rather than aid the respondent number 1, establishes two parts, that Section 10 of the General Clauses Act applies to election petitions.
Yeah.
And I would only have to satisfy your lordships, that the 45th day was a holiday, and immediately thereafter I have filed it before your lordships. That is borne out by my affidavit and the registration date as carried out by the registry of the Honorable Court, that on 17th my election petition has been registered before your lordships.
Why was 14th holiday, Mr. Thapa?
We are just confirming, probably Ambedkar Jayanti. We'll just confirm from the court's calendars. Ask the court master. So,
that will be relevant also, yes.
No, because that would be the 44th day,
Whatever, yes.
Then Saturday becomes 45th. So, for all practical purposes, if we apply Section 10 categorically,
the next judgment you want to answer to?
The other judgment is the one that they have placed from, again the Supreme Court of India, the Manupatra citation. This is Sadbir versus Parsani Devi, Again, same issue. The notification is again reproduced. Your lordships would see, on the first page. This is the notification dated 20th of November 1981.
81?
This is the judgment, this is Sadbir versus Parasani Devi.
Oh, sorry, yes. I was looking at the live law one. Okay.
This is Manupatra, Again, the notification
Same
is...
High Court.
Yes, it is hereby notified for general information that the High Court of Punjab and Haryana will remain closed for civil business except for hearing election petitions and other matters arising out of the Representation of People's Act. And your lordships, it says, para 2, in view of the clear language of the notification, there is absolutely no doubt that the appellants had to file the petitions in the High Court before the expiry of 45 days, and for this purposes, the High Court would be treated as opened. That is not the case here, my lord. So this is of no assistance insofar as the petitioners are concerned. Applicant is concerned. The live law judgment, my lords, is again. My lords, here what has happened is.
It's see particular facts of a case.
No,
only.
here, my lords, even more interesting is the application seeking dismissal of the election petition, my lords, has been rejected by the court. Last paragraph, if your lordships kindly see page 21.
Yeah. Para 21.
Para 21, my lords. It's been dismissed, but this is otherwise, my lords, I would respectfully submit, my lords, it is not an authority. It is only on the relevant facts of this case. So 1999, my lords, only for the purposes of whether General Clauses Act would apply or not, my lords, it applies.
Yes.
And otherwise, my lords, there is no dispute in so far as the 74 cases concerned or the other cases authorities place that limitation does not apply. Because if limitation applies, my lords, General Clauses Act will not come into play.
Yes.
So in the facts and circumstances, my lords, I would humbly submit that there is no delay. We are squarely covered by Section 10 of the General Clauses Act. And my lords, one issue I had, my lords, even at the initial stage, I pointed out, and your lordships have recorded in this application as well, that the rules, my lords, require leave of this honourable court be sought before filing of any application.
That's recorded. We recorded that, but then that we have.
Well, since this election petition will now go the whole hog, well, I would at least feel that way. If it falls from your lordships, my lords, that the procedure is established under the rules, my lords.
It's already there, Mr. Paul, with regard to we have adopted the County High Court rules with regard to.
My lords,
that's already the other connected.
Then in that event, my lords, that your lordships would have to, but if I may.
I've kept on insisting every time when the matters were initially filed by all the parties that, lordships, you know, that this is the.
I would respectfully then submit, my lords, that this application would have to be rejected even on that ground. How I leave it to your lordships, because on merits, I think I would otherwise succeed.
Yes, we'll pass order.
All right.
Item number 9.
Wait, please, your lordship. Your lordship, I'm praying for some time, your lordship, to file the affidavit. I'm awaiting.
No, complied. What is the infraction or violation?
DCRC, lordship.
DCRG?
Yes, lordship.
Your lordship, here before we release the DCRG, a report is to be obtained from the examiner of local accounts. Your lordship, the documents and all the relevant documents of the petitioner have been forwarded to the examiner of local accounts. So your lordship, from our part, your lordship, there's
so
no
then there's no violation. It's not that they're saying we won't pay you. The process of
the report is awaited, your lordship, from them.
Let them take the instruction.
No instruction of contempt anyway. This up to 2 weeks.
Obliged, your lordship.
For further instruction from the Leonard GA. Yes.
10.
My lord, I am appearing for the district council in this matter. It appears, my lord, there is a civil dispute between the private party and the petitioner. Private party, no one has appeared, my lord, yet.
There's any suit pending?
No.
They have to file a partition suit.
Because only the not party, that is not the disputed. The government, the district council has time and again issued letter to the respondent to issue patta, joint patta in the name of the petitioner as a respondent number 8.
I think you have to file a suit because you are seeking declaration.
I'm not. This is not a declaration. Only then? To carry out the order of the respondent's lordship.
See, what has happened here that by own synopsis you say that is objection to stop mutation.
Moreover, the respondent tries he come to the court to seek the same relief, Lordship, against that order, Lordship. That has already been withdrawn thrice.
To be decided by the civil court because as far as I remember, the matter was withdrawn by Mr. Dev. There, my lord, he said that they have a will. If it is a will, then they have to provide it, my lord.
It's their will.
They are claiming.
They claim, but they could not produce in the district council, Lordship, because there is several orders. The revenue appeal. Let them to file the video.
You file a small affidavit, Mr. D. Yes, at least I'll go on record. Yes, Mr. D, General Counsel for 127, prays for 2 weeks time to file an affidavit stop. None appears, we have somebody, this for number 8. Just after 2 weeks.
Item 11.
Your Lordship, here in this matter, I'm praying for further 1 week's time, Your Lordship, to file the affidavit.
Your Lordship, we've given them the revised order.
MS Esrum for petitioner plays for the 1 week time to file affidavit just after 1 week. Yes.
Right, Your Lordship.
12.
Please, Your Lordship, I will be allowed some more time to, because I am yet to receive instruction to file reply.
MS Esrum prays for not for a 2 weeks time to obtain instructions just thereafter. And so on.
13.
Well, please, Your Lordship. Lordship, there's a new development in this case, my lord. Lordship, they have come up with a new order, my lord, against the petitioner.
This is you have to go again for third time now litigation.
The third round of litigation now.
Third round you have to go then.
I may be permitted to withdraw this petition with the liberty to file afresh, my lord.
The Council of Petitioner submits that after the incident petition been filed afresh as allowed by this court, White Order dated 26/9/2022, there has been some further development for which there is a necessity to withdraw the incident application also with liberty to file afresh. In view of the submissions of the Council Petitioner, the matter stands close on withdrawal with liberty as previous.
Hello,
14.
This is a matter, my lord, where I am seeking appointment in competition ground, my lord. My petition, I have submitted the petition before the authority concerned, my lord.
It just come first time, they let them find affidavit.
This is the second time it's coming.
After motion?
Yes, after motion this is coming.
How much time has Srumthao?
3 weeks time.
Yes, MS Srumthao, Vice Chancellor, prays for and allowed. Second time.
Let it be 2 weeks because it's disposal of my representation only.
They'll ask for time, pays for about 3 weeks time for affidavit. This thereafter also.
Hearing item 18.
This is the Balpakram matter, my lord. On the last date, because they raised the issue of the first registration certificates, whether it has come, my lord. We have the Xerox copy, my lord. We have applied for the certified copy of the first one, which is lost. So, my lord, in this, my lord, I'll just pass on, my lord. I'll produce the certified copy in this, my lord, because what was raised is that it was when the case was filed, and because we have subsequently brought on the notice of the renewed. So what was brought was
it was first registered on
2002, my lord. 2002, and in this 2002, my lord, if my lord says there is no validity, my lord. It does not say anywhere that on such period it gets.
Never says here.
It has not said.
You're under the Act,
my lord.
It's under the Meghalaya Society Registration Act. Yes,
my lord. So because the original was lost, and for that purpose, my lord, subsequently, my lord, we had and we.
No, there is objections to say that you are a defunct association.
Defunct associations,
and so you can't maintain any.
REIT, my lord,
yes.
by the associations, my lord.
Yes.
This was what raised, my lord. So So these certificates, my lord, these certificates nowhere says that such period.
Look at the act. Where's the act? Society Registration Act. Meghalaya Society Registration Act in 1983.
Do you have Meghalaya Societies Registration?
Look at it from the net.
My lord, I have Meghalaya Registered Societies Act, my lord. I have here.
Yes, see, what does it say, Mr. Sen? What are your objections? Both forgotten also.
So, in fact, this was an objection that lordships had taken. In fact, lordships wanted to examine two things. One is whether this registration was still in sustenance, and number two, they have enclosed a copy of a power of attorney. In that power of attorney, there is a particular stipulation. If lordships will kindly have the writ petition, page 11.
Yes.
Kindly see clause 5.
Oh, that share.
Lordship. So there is a reference to another agreement dated 16th June 2012. So lordships had directed them to place the original of this agreement as well, since lordships had observed that this involved public money.
Yes, Mr. Yubin.
My lord, that 16 is a resolutions, my lord. It's not agreement, it's a resolutions.
Resolution also
It's a
like
resolution.
condensing the minutes of a meeting.
My lord, my lord.
Yeah, what does it say, resolution?
Oh, registration, my lord. I'm not coming across the validity, my lord.
No, I'm on the resolution of this
Period of limitation. Oh, no, I'm sorry.
Not limitation.
Well, can
The
you
renewal
comment?
clause, just check.
Appointment of the society association. Authorization name of the society. Organizations. Limitations. General meeting. Of the society. Distribution and the society. The previous one. Section. Limitation तो है नहीं ऐसा registration का. But validity of the registration is not provided in the act, my lord.
Correct.
Subject to. I'll have to just examine that notes by looking at the rules as well.
Because by the act.
Where's that report of number 4, 17/2012? Which page is it?
You know, that is at page.
Page 30,
36 to 39.
36, my lord.
So their prayer is that they should be paid compensation. As per this report.
This is not 17. If they're asking response number 4, 17/8/2012. This is letter 17.
At page 36 minutes.
36 is something else. It's 12/24 December 2011.
So that is what I have in my petition. It's a letter dated 17th of August 2012, issued by the Deputy Commissioner. May I just assist, my lord?
Oh. Because, my lord.
Oh, got it. Yes. Here's How can you have 2 page 36? What is the type copy? Okay, sorry, yes.
Type 2. The DC's conclusion is at page 39.
Yeah. Who was the DC at that point of time?
This point of time.
This it had come before this court before. What is the judge? What is the order?
That's that is at page
13.
14. Page 13 onwards, the relevant part is at page 16, 16.
There is another order before this court, my lord, page 62, where the court has directed to dispose of our representation with speaking order. And what my friend is saying, page, that is the Guwahati High Court's order.
Well, the genesis is from this order. Kindly see this order, page 16 onwards.
But the Guwahati High Court order never said, my lord, it has not closed out order. It only says that we have not, it was disposed of on non-exhaustion of alternative remedy, my lord.
If lordships have that, I'll just indicate what has happened here. There are a batch of writ petitions which were disposed of by a common order of 2nd of March 2011. Kindly have page 16, I'll just read that out.
Yes.
This reads, this batch of writ petitions arising out of the alleged taking over of Aking lands for the purpose of Balpakram National Park in the GHDC with the consent of the council appearing for the parties are taken up together for hearing and are being disposed of today by a common judgment. In WPC number 315 SH of 2002, this is in relation to Balpakram's writ petition. The others are in relation to different writ petitions. The petitioner is an association of Nokmas of the Aking lands situated in South Garo Hills, Meghalaya, and is registered under Societies Registration Act number so and so, dated 2nd September 2002. In the year 85-86, the state government, for the purpose of setting up Balpakram National Park, proposed to acquire the said Aking lands in several phases. In the first phase, 10 Aking lands with an estimated area of 220 square kilometers were acquired at the cost of 3.36 crores at 1.65 lakhs per square kilometer. Again in 91-92, another area of Aking land estimated to be 76.25 square kilometers was acquired at the cost of 1.26 crores at 1.65 lakhs per square kilometer. Thereafter, in the year 94, an additional Aking land of 15.5 square kilometers was acquired at the cost of 25.69 lakhs and was handed over to the Forest Department on 19/4/94. Again in the following year, that is 95, another Aking land measuring 39.91 square kilometers was acquired for 65.85 lakhs at 1.65 lakhs per square kilometer. In this manner, a total of 352 square kilometers has been acquired till 95-96. However, in the year 96, an additional Aking land measuring 114.85 square kilometer was sought to be acquired from 8 Akings for the purpose of expansion of the park. It is the case of the petitioner that except for this 114.85 square kilometer of land, no proper land acquisition proceedings were initiated apart from issuing notifications purportedly under section 4 and 6 of the Land Acquisition Act, and that the unsuspecting illiterate Nokmas were made to sign on blank papers which were made out to be agreements. They were never informed of their right to receive money under protest or their entitlement to higher compensation in the absence of adequate compensation. Moreover, according to the petitioner, in assessing the rate of compensation, the respondents totally ignored the rate fixed by GHDC and paid them 1.65 lakhs per square kilometer, which worked out to be a mere 200 rupees per bigha. While determining the quantum of compensation, the value of standing trees, crops, mineral deposits, etc. were not taken into consideration. Solatium was also not paid, ignoring the provisions of the Act. Now, from the own pleadings of the petitioner, it becomes obvious that the landowners represented by it are aggrieved by the quantum of compensation awarded to them between 91-92 and 95-96. In my opinion, it is now too late in the day to challenge the award made some
7 to 15 years before. Moreover, if the petitioner is really aggrieved by the quantum of compensation so awarded, it had the remedy under section 18 of the Act for reference by the collector to the Land Acquisition Court, provided that it was filed within the period of limitation prescribed thereunder. Having not done so, the writ petition insofar as 352 square kilometers is concerned is barred by non-exhaustion of an alternative statutory remedy. As for 114.85 square kilometers of the Aking land, the state respondents at para 11 of their affidavit on opposition dated 11/12/2002 have clearly stated that this additional land comprising of 8 Akings is yet to be acquired. This position is reiterated by them in para 10 of their latest affidavit in opposition dated 18/8/2010. It is also categorically asserted by them in para 19 therein that the Forest Department does not occupy or use any of the aforesaid land and will not do so until the same is properly acquired and handed over to them by the district collector. This is reaffirmed by the Chief Conservator of Forest Government of Meghalaya in his affidavit dated 10/9/2010. In the light of the categorical declaration made by the state respondents that they are yet to acquire Aking land measuring 114.85 square kilometer, no mandamus can be issued by the court for directing them to pay the compensation. To this extent, the writ petition appears to be premature. It shall, however, be open to the petitioner to approach his court again if the state respondents decide to take over possession of the Aking land in question without payment of compensation or following the procedures laid down by the Act.
One thing, and the thing is that now where is that ordered in 17/2012 find place? How can a deputy commissioner again make a how can he make a reassessment when it's the court has settled it?
And Manoj, may I just point out, it is not a case of reassessment, it is his view that perhaps reassessment should be done.
No, whatever views been expressed, views been expressed. But what authority did he have to? He was not aware of this order of this court.
My lord, it is for the respondents to come up with an
No.
affidavit and explain this. My lord, it is their
Did he challenge
order,
this order?
My lord, it is their order, my lord.
No, one thing, Mr. Human, did he challenge this order before any before another writ appeal?
The order of this writ petition, my lord, which passed by the Guwahati High Court, my lord, that was not challenged, my lord.
Why?
That was not challenged, my lord.
Let me satisfied that with regard to your barred by delay, and so he said that when the court's not venturing to decide your rights because it's 15-16 years after.
My
So
lord,
that closes the entire matter regarding your 352 square kilometers. With regard to the new 114 point something square kilometers,
that is not acquired.
That is not
So that's not
acquired, and so that's the
subject.
process
Yes, my
of.
lord.
So what are you seeking by this instant petition now
My lord,
for implementation of that of the view of the deputy commissioner?